Canada is back open for business. Now, we're going to get in, before we get into this article, CTV News talking about the Supreme Court's toppling of the endearingly named No More Pipelines bill, or officially Bill C-69. I wanted to get over to this other article that came out back in 2019 with ATB Capital Markets, where they were just going over what Bill C-69 is. That way you know the highlights of why people around Canada are cheering so much for the Supreme Court's decision, and we'll get back to an article on that. So it says, what is Bill C-69? The bill names the Impact Assessment Agency of Canada as the authority responsible for impact assessments and establishes a planning phase for impact assessments of designated projects, which includes requirements to cooperate with and consult certain persons and entities, and requirements with respect to public participation. It enacts the Canadian Energy Regulator Act, which establishes the Canadian Energy Regulator and disbands the existing National Energy Board and sets out its composition, mandate, and powers. The role of the regulator will be to regulate the exploitation, development, and transportation of energy within Parliament's jurisdiction. Generally, that's interprovincially or internationally. Overall, 99 amendments were made to the final bill. So, what are the key issues? Bullet point 1, indefinite pauses to regulatory approval processes. As you know, there are already a bunch of hoops that you've got to go through if you want any type of project to go down, especially in oil and gas. So, while the Act shortens the time frame for assessments by the regulator from 365 days to 300 days, and for the review panel's assessment from 720 days to 600 days, the legislation allows for unlimited resets of the planning stage from the governor in council. While the potential for indefinite delays remain, amendments to the bill have moved this power from the environment minister to the governor and council. Okay, so indefinite approval process. That's one reason people don't like it. Potential involvement of unrelated parties. Sounds great. The planning phase of assessments originally required the applicant to engage with anyone choosing to intervene in a project, not necessarily just those with a direct vested interest as stakeholders. Amendments to the final bill have attempted to address this by giving the regulator the power to decide who can intervene. So this is something, I mean, it sounds unrelated, but this is why there's such a housing crisis in places like California in the United States, because third parties can get involved and hold up the permitting process for building projects and hold them up for years and make them cost millions and millions more, which means if a project even gets made, which that's a big question, if it does get built, the cost now to get into it is astronomical, because anyone involved with building that had to pay so many lawyer fees to get these third parties out of there. All right, next, additional ambiguity. While the Act calls for science and evidence-based findings, it also specifies that certain ambiguous concerns, such as traditional Indigenous knowledge, potentially resulting in contradictory findings with the first required noted, sustainability, as well as the intersection of sex and gender with other identity factors, must be accounted for in the decision-making process. Now keep in mind, this is for oil and gas projects. So we've got to have some intersection of sex and gender considerations here. Assessments that proceed to a review panel. must allow, if appropriate, the admission of evidence that would not normally be admissible under the rules of evidence. Okay, and next, final decisions rest with the Environment Minister. Despite amendments to the bill, which have limited the powers of the minister, specifically the minister's ability to single-handedly delay projects indefinitely, the act specifies that all final decisions will rest with the elected minister's office, leaving the ultimate decision with the minister, potentially leading to increased politicization of projects in the future. So you can read between the lines, you can see why this is called the No More Pipelines bill. Now we're going to jump to the future, to now. The CTV article titled Supreme Court Rules Against Federal Environmental Impact Assessment Law. Canada's top court has ruled the Federal Impact Assessment Act, IAA, also known as Bill C-69, is on balance unconstitutional. On Friday, 5 out of 7 judges ruled the environmental scheme as too broad in its assessment of the environmental impacts. Environmental protection remains one of today's most pressing challenges, said Chief Justice Richard Wagner. To meet this challenge, Parliament has the power to enact a scheme of environmental assessment. Parliament also has the duty, however, to act within the enduring division of powers framework laid out in the Constitution. The bill, enacted by Parliament back in 2019, provides a process for assessing the environmental impacts of designated energy projects. It also allows for more public consultation and participation in the assessment of any future energy projects. Think back to that third party we were talking about. The legislation's critics have called it the No More Pipelines bill. The province of Alberta sent it to the Alberta Court of Appeal, which ruled the legislation unconstitutional in 2022. Ottawa appealed the decision to the Supreme Court, and arguments were heard last spring. 9 out of the 10 provinces oppose the scheme. Quote, the scheme's decision-making mechanism therefore loses its focus on regulating the federal impacts, Wagner said. Instead, it grants the decision maker a practically untrammeled power to regulate projects, regardless of whether Parliament has jurisdiction to regulate a given physical activity in its entirety. The designated projects section of the legislation, which includes projects set out under the regulations of the bill and those subject to ministerial orders, is the section the Supreme Court ruled as unconstitutional. Alberta Premier Danielle Smith said she was extremely pleased with the Supreme Court decision. And I saw she had maybe a 45-minute to an hour press conference praising this decision when it came out on YouTube. I'll put a link in the description to it. Quote, if you believe in fairness, common sense, and the sanctity of the Canadian Constitution, then today is a great day, said Smith in a press conference with reporters in Calgary. Quote, today's decision significantly strengthens our legal position as we work to protect Albertans and all Canadians from federal intrusion into our provincial jurisdiction. However, the judgment does rule that sections 81 through 89 or through 91 in the bill, which relate to the federal government's right to conduct impact assessments on projects carried out in the federal and in federal land and impact federal jurisdictions, are constitutional. And they're the same. Because the environment, by its very nature, is broad, there should be a level of flexibility afforded to regimes to regulate that regulate it. On Friday, Environment and Climate Minister Stephen Guilbeault said the federal government accepts the ruling acknowledges the bill needs to be, quote, tightened. Quote, we will now take this back and work quickly to improve the legislation through Parliament, Gabot said in a virtual press conference with reporters. We will continue to build on 50 years of federal leadership in impact assessment, end quote. In the drafting of new legislation of the bill, Gabot said the federal government would follow the guidance from the court and collaborate with provincial and Indigenous leadership. In Vancouver, Conservative leader Premier Poilievre also reacted to the ruling. Quote, today we learned that the Supreme Court of Canada has found Justin Trudeau's No New Pipeline anti-resource law unconstitutional, he said. A Poilievre government will repeal this law entirely and replace it with one that consults First Nations, protects our pristine environment, but gets jobs approved. Environmental groups expressed their disappointment in the court's advisory ruling. Quote, the federal government must move swiftly to restore the constitutional legality of the act, reads a statement released by Environment Defence Canada. Quote, federal oversight is crucial given that environmental issues are not contained within provincial borders. And it's especially crucial when provinces aren't taking environmental responsibility seriously, or, as the case may be, are outright hostile towards environmental protection. So there you have it. There's kind of all sides, but as of right now, Canada is back open for business. What we're hearing on the ground is that a lot of companies are taking Q4 budgets to get permits and leases so that they are ready to go and bust out the doors in Q1 of 2024. How about you? What do you think about the overturning of this bill? Is that good? Is it bad? Are you experiencing impacts from this in your business? Please let me know your thoughts in the comments. A link to this article and more are in the description. If you like what you heard, please don't forget to like and subscribe so you can continue to get more energy, science, industry, and regulatory news that you need for your work and investments in energy. And remember, with science in our hands, fossil at our feet, knowledge in our heads, and God at the helm, the future is ours to build.